Good morning, ladies and gentlemen. My name is Willem van der Brugge, and I am the Secretary General of the Confederation of European Probation. And we are delighted to have you here to participate in the second edition of this CEP online event on alternatives to pretrial detention. But before we start, let me briefly introduce the Confederation of European Probation, CEP. CEP is a non-political, non-governmental organization which brings together probation services from all around Europe. In 1981, it was the number of foreign national prisoners in Europe that gave, at that time, 11 members, at that time Western European countries, of course, cause to join forces and found CEP. And CEP is the single largest European network organization for the sector of probation and community justice, with the capacity to reach probation staff at both a managerial and an executive level. So I mean practitioners, middle managements. It includes also academics and researchers in probation from all over Europe, both as individuals and as member universities and research institutes. And CEP promotes pan-European cooperation in the development and delivery of community sanctions and measures. CEP has its headquarters in Europe, in Utrecht. Let's go to today's event on alternatives to pretrial detention. In Europe, we know that about 22% of the inmates held in European penal institutions are not serving a final sentence. And following the terminology of the Council of Europe, this means that 22% of the inmates are detainees placed in pretrial detention. It should be noted that in Europe, an important part of the population in pretrial detention are so-called foreign nationals. Especially in the European Union countries, the percentage of foreign nationals in remand-placed pretrial detentions is relatively high, approximately almost 60%. The overuse of pretrial detention emphasized the importance to promote the use of alternative measures to pretrial detention in Europe, not only because the prison overcrowding is still a big problem in many countries. In this webinar, we want to address the different mechanisms that influence the high number of detainees placed in pretrial detention. For today's webinar, we invited 3 experts to lead us into the topic on alternatives to pretrial detention. Actually, I must say 4, because we have a presentation where we start with Dr. Alexia Jonckheere and Dr. Erik Maes, both senior researchers at the National Institute of Criminologists and Criminology, NICC, in Belgium. And they will lead us into the use of alternatives to pretrial detention, dilemmas and challenges. The second speaker is Dr. Kresimir Kamber. He is a lawyer at the European Court of Human Rights in Strasbourg, and he will present alternatives to pretrial detention in the case law of European Court of Human Rights. And the last presenter will be Dr. Adriano Martufi, assistant professor at the Institute of Criminal Law and Criminology in the Netherlands. The title of his presentation is intriguing: Alternatives to Pretrial Detention, Underused, Ineffective or Useless, a Normative Appraisal of Non-Custodial Alternatives to Pretrial Detention under European Law. Of course, there are some household announcements. After each presentation, we will take some time for questions and answers, and CEP Policy Advisor Mirka Yakosova will keep track on the questions. And you are welcome and invited to actively take part in the Q&A sessions. This can be done by both the Q&A and the chat function. And good to know is that this webinar will be recorded and that the presentations will be published on the CEP website after this event. And so far, my introduction, and I suggest that we start with the first presentation. Dr. Alexia Jonckheere and Dr. Erik Maes. And as said, they will lead us into the use of alternatives to pretrial detention, dilemmas and challenges. Dear colleagues, the floor is yours.
So I'm Erik Maes, and I, together with colleague Alexia Jonckheere, we want to present you, we will focus in our presentation on the alternatives to pretrial detention, and we will take Belgium as an example. And this presentation is based also on the results of a project that was funded by the European Commission a couple of years ago. It was the Detour project. And many of these findings were also confirmed in a roundtable discussion that was organized on the initiative of the Belgian Minister of Justice some months ago. So on the 10th of June, there was a roundtable discussion that took place in Brussels with some Dutch and French-speaking practitioners, and this concerned prison governors, public prosecutors, investigating judges, and defense lawyers. And this roundtable was also recorded, and you can watch the roundtable. It was a roundtable of 3 hours. You can watch it also on YouTube, and there below on the slide you find the link to the website of the Belgian Minister of Justice, where you can find the video records of the link to the video records of the roundtables, but also the speech of the minister, and also some figures about pretrial detention in Belgium. These roundtables were announced in an action plan that the Belgian government submitted to the Committee of Ministers of the Council of Europe in the end of March. And in this action plan, the Belgian government reports on different actions that were undertaken or that are planned in order to tackle prison overcrowding and the bad detention conditions in Belgian prisons. And this stems from obligation Belgium is committed to by judgment of the European Court of Human Rights in the case of Vasilescu and also other cases. And in this action plan, the Belgian government also refers to the existence and the investment in alternatives to detention, more generally speaking. On the same date of the roundtable discussion in Brussels, the Committee of Ministers of the Council of Europe also adopted an interim resolution in which it invited once again the authorities to raise awareness among practitioners in order to increase the use of alternatives. So the question is, are there alternatives? Which are the alternatives that are available de jure, so in legislation, and how often are they used? In Belgium, since long ago, several alternatives exist in Belgian legislations. For example, financial bail. It's an alternative which exists for a very long time, and it consists of a deposit of an amount of money, which is determined by the judge. Besides that, we have also the release under conditions, freedom or release under conditions, which means that the suspect can be released with specific conditions. There's no limited or exhaustive list of conditions that can be imposed, and it concerns obligations and or prohibitions. A more recent alternative, it's not really an alternative, but I will explain this later on. It is electronic monitoring within the framework of pretrial detention. It was introduced by a law of December 2012, and it is operational since the 1st of January of 2014. Besides this, of course, also the suspect can be released without conditions, without any conditions. With respect to the different alternatives that exist, it is important to notice that the same criteria as for remand and custody applies to these alternatives. And the criteria for the application of remand custody, so the issuing of the arrest warrant, are as follows. First of all, there must be serious indications of guilt, an absolute necessity for public security. The criminal act must be punishable with a prison sentence of 1 year or more, so at least 1 year prison sentence. And in case of a maximum prison sentence of 15 years or less, the decision must be grounded on additional grounds, such as the risk of recidivism, the risk of absconding, the risk of tampering with evidence, or the risk of collusion. For an arrest warrant, there's no absolute maximum length provided by in law, so the remand custody can also last for many years. For freedom and release on the condition as an alternative, this decision can be imposed for a maximum of 3 months, but it is also renewable. As I told you, electronic monitoring is not really an alternative. It's more a modality of an execution of an arrest warrant, like in Austria, for example. And there are also several consequences. This means that there was also a regular review of the decisions by the investigating courts, as this is the same for the regular arrest warrant. Also, the time spent on the electronic monitoring will be deducted from the final sentence that the sentencing judge will impose. And there will also be a compensation in case of unlawful detention. Electronic monitoring within the framework of pretrial detention is very different from the system or the regime for convicted offenders in this sense that the regime is very strict. So there is no individualized or fixed time schedule. It means concerns 24 hours each day home detentions. So the possibilities to leave the assigned residence are very limited. There's also no maximum duration, but there is a regular review of the decision. And here, in this case, we don't use radio frequency technology, but rather GPS technology. And there's also no intervention for probation supervision or probation service. So there's no assistance, no guidance, social guidance, which is provided in this framework. So Alexia will now go further on with exposition on the challenges and problems in the use of the alternatives.
Good morning. Thank you for this possibility to explain what about pretrial detention and alternative in Belgium. I will now continue this presentation, firstly by explaining some problems of each alternative measures, and secondly, by underlining the global dilemma that currently exists in Belgium regarding their use. The financial bail is little used in Belgium as in other European countries, mainly for a question of principle. The freedom and the absolute necessity for security cannot be bought, but also for the inequality of the measure perceived as a privilege for the rich, for the poverty of many suspects, its irrelevance to the risk of absconding, a possible doubt about the legality of the funds, and consequently, the fear that authorities will be laundering criminal proceeds, and lastly, for an unfamiliarity with the applicable procedure. With regard to the release under conditions, we first observed that the measure is mainly ordered after a period of pretrial detention in such a way that it can reduce the length of the pretrial detention, but not the number of entry in detention. Also, certain types of suspects with a particular profile face more difficulties to get a release under conditions: drug addicts, sex offenders, suspects with alcohol or psychiatric problems, and so on. We have also a lack of specific institution for those people and long waiting lists. It is also not so easy to organize intake interviews with pretrial detentions, and some suspects are not asking for treatment or being difficult to motivate. For condition of release, we observe a wide variety of conditions, standard conditions imposed in a pro forma manner, but also tailored conditions that depend on the suspect's situation and include diverse categories: restriction on movement, communication restriction, daily occupation, medical treatment, social guidance, and so on. These conditions are more or less intrusive and sometimes unnecessary or disproportionate. They may be also expensive. For instance, blood tests for drug users are expensive and have to be paid by the suspects themselves. We also note that criticism are sometimes made in terms of control of compliance with conditions, which reduces the trust of the actors in such measures. But the biggest problem is the overrepresentation of foreign nationals in the pretrial detention and their underrepresentation among the population on release under conditions. A distinction can be made between different subgroups of foreigners. Do they have a permanent address or a regular residence permit in the country? Do they have financial resources? Do they have familial bonds? If one or more of these factors are lacking, pretrial detention is viewed as the only answer because there will be a high risk of recidivism. With respect to electronic monitoring, we observe a limited and disparate use. there are several problems that explain it. Firstly, there is a lack of knowledge and information about the technology of electronic monitoring. There is also a fear or additional administrative workload for judges who have to deal with breaches or electronic monitoring conditions or with respect to the practical and technical implementation of the technology. It is not clear whether the electronic monitoring can prevent the risk of collusion, absconding, and recidivism, and some specific suspects are also excluded from the application of the measure. Offenders with mental health problems, foreign national with legal residence in Belgium, homeless, and so on. But also specific offenses are excluded, such as drug dealing, domestic violence, and so on. Another explanation is perhaps that the very strict regime of electronic monitoring is comparable to a 24-hour home detention, as Eric explained. The measure includes also some discriminatory aspects. Not every suspect have the same level of comfort in their home. And finally, we observe negative impacts of electronic monitoring on suspects and their families. For instance, a psychological pressure. It's a bad experience for the whole family. But despite those problems, we observe that alternatives are increasingly used to the extent that we have an important dilemma. By promoting alternatives, are we not encouraging mass supervision? We observe two trends. The judicial supervision with conditions is more and more used, and the pre-trial detention is also more and more used. And there are suspects who in the past would have been released without conditions and who nowadays will be placed under judicial supervision. Actually, there is a fear of releasing too fast. So in Belgium, we observe a progressivity in pre-trial measures. Suspects are first in pre-trial detention in prison, then in pre-trial detention at home under electronic monitoring, then release with conditions, and finally release without conditions. In this graph, we observe the evolution since 1990, the year in which alternatives to pre-trial detention were introduced in Belgium. Since this introduction, we have twice as many suspects in prison, and alternative measures are increasingly used, while we have a stability in crime rates. So the available statistics demonstrate a net widening effect linked to the use of pre-trial detention. In conclusion, in Belgium, the so-called alternative measures are in use, but they are much more used as complementary measures rather than replacement measures. They pose also certain problems, such as problems of discrimination. The focus on the risk of recidivism probably explains the still massive use of pre-trial detention. And there is also a media pressure. Every time a case is covered by the media, there are always calls from the public for pre-trial detention, and magistrates sometimes find it difficult to explain that a suspect must remain free in the name of the presumption of innocence. So we have to build a better communication with the general population. And probably we should also have more radical solutions. For instance, maximum prison capacity for pre-trial detention, obligation to use electronic monitoring instead of pre-trial detention in prison, limitation of the pre-trial detention to certain specific offenses, a more important deduction of pre-trial detention length on the final sentence. All of these proposals have been made in the past and have just been made again by lawyers in the context of the Vasilescu case. I thank you for your attention.
Okay, thank you, Alexia and Erik. We now have time for some questions. I'm looking to Mirka. Are already some questions coming in?
Yeah, first of all, thank you for this very interesting presentation. So far, we have no question in a Q&A, so I would encourage our participants to use chat or Q&A session. And if I may kick a question, Willem.
Yes, you may.
that I was very interested by lack of knowledge about technology of EM. By this, you mean like lack of knowledge of all the judiciary or probation officers, or can you maybe more elaborate on that? Because in my country, we kind of promoted a use of electronic monitoring, and with us, it was more about fear, not about lack of knowledge. That's why I'm interested how this in your country.
Especially when it was first introduced and it became operational on the 1st of January 2014, and electronic monitoring is supervised by it was supervised by a section of the probation service, and they did not make a lot of promotion on this because they had already a very high caseload for electronic monitoring of convicted offenders. So there was, from the side of the probation service at that time, there was not a lot of promotion activities that were launched. So in the first years, it was not so much applied in Belgium. Although there are many differences according to judicial districts. There are some judicial districts where it's very popular, where it's used very often, and there are other judicial districts where it's not often used. And I think there's also continuity over time. Even if they know now how the system works, they are against the use of electronic monitoring. Fear, yeah, there's a certain fear also for a caseload, for growing, that they will have more administrative tasks to do, and especially fear from the judiciary. Because if there was a breach of the condition, or somebody comes too late at home, and they have fear that they will be contacted by the supervising center all the times. So,
yeah.
Maybe I can explain also an experience in Belgium for the judges to encounter the lack of the understanding. They put a few judges under electronic monitoring to improve the technology, and it was an experience to understand what's the effects of the electronic monitoring on the suspects.
Yeah, and a couple of years ago, there was another initiative of the Minister of Justice. There was also a formation, a training that was provided by the Institute for Judicial Training. It was a whole journey where everybody, where the probation service was invited, prison governors were invited to explain the system and how it works.
Yeah. I have a question too. You mentioned, Erik, that there are differences between the various court districts. Is there also, and that's obvious if we talk about Belgium, a difference between Flanders and Walloon?
Oh, no. Concerning electronic monitoring, we see even in Flanders and in Wallonia, that's limited to some judicial districts. So there's also disparity in Wallonia as it is in Flanders.
Yeah.
So, for example, in Flanders, it's very much often used in Antwerp, but in Ghent and Bruges, it's almost never used.
Yeah.
So, and the same is true for Wallonia. So at that point, there were not so much differences between the different regions in Belgium.
Okay. Alexia, you mentioned the media pressure. I think that all participants will recognize that. Can you elaborate a bit more on that?
Each time we have a case in Belgium, the media pressure, and not press media, but also Facebook and so on, the public ask to more repressive measure, and the public don't understand. We have to wait a long time before the process. I think it's the most important problem. After 3-4 years, we have the process, but it's a long time to wait the process, and the judges will don't want to use the pretrial detention, but in the media, with the media, it's impossible to keep someone in liberty.
I think there was also a task to educate the public opinion, or to inform the public opinion about the sense and the nonsense of pretrial detention, and why yes, that it should be exceptional also, because it does not, the people are not yet convicted yet. So yeah, there has also to be not only awareness raising amongst protectionists, but also towards the public opinion.
Yeah. I think that is what we have to do in general, as prison and probation agencies, to tell our story. We're not used to that, and it's about creating public value. I think that, as you said, the media has become so important, and nowadays they only react on incidents and not on what we do on a daily basis. Yeah. I see, Mirka, is there a question coming in? Yeah.
We actually have a question and one attendee who's raising hand. So I will first address the question. It's from a person nicknamed IRKS, and the question is: are there any alternatives that are also used with non-residents in Belgium, and which ones?
According to legislation, everything can also, there's no discrimination between residents or non-residents, but in practice we see that we see an overrepresentation of foreigners in the prisons, and an really very high underrepresentation of foreigners in case of alternatives. So mostly in practice they are included. There may be a small problem that they are excluded from alternatives, especially, for example, when it concerns electronic monitoring, because you have to have a fixed residence, so things like that. What is sometimes used is financial bail. That's an alternative that's much often used for foreigners instead of Belgian citizens. But real alternatives concern, there's also a relationship with reintegration, for example, treatment or to work or things. And sometimes, for foreigners, especially when they are not from the European Union, it becomes very difficult to apply alternatives to them. And for the European citizens, yes, we have also the European possibilities at the framework decisions and the European arrest warrant or the European supervision order. But there is, especially the European supervision order, is very less used, I think. We don't have figures about that, but there's also very less known among practitioners. So also in this case, we have to also invest more time and pay more attention to inform also the judiciary about the possibilities. But there, I think also there's also some fear of administrative workload and organizational logistic problems. And yes. Yeah.
Thank you. We then have one attendee which wants to raise hand, which wants to ask a question. We still have time, so I will. Hello, can you?
Yes, can you hear me?
Allow me to talk.
Can you hear me?
Yes.
Good. Well, the way I look at it is it not a question of what is the better of two evils? Pretrial detention is not good, obviously, because you are keeping in detention someone who is yet to be found guilty. He is still innocent until he's found guilty. On the other hand, letting him out on condition or on bail security is equally bad because he is buying his freedom, or in a way putting a security for his freedom. And just the same way, the electronic monitoring is an infringement on his freedom of movement. So he is not being treated as a normal human person like rest of us. On the other hand, you have to weigh out the balance of his freedom and ability to go and work, be with his family, be able to go to the shops, etc., or be staying in prison. Which is better? I think at the end of the day, the judge will have to weigh up on the balance whether it is worth keeping him in detention, which is also costing money, because keeping someone in detention costs money, security, food, clothes, etc. But sending him out is costing his freedom, but then he is getting the benefit of being able to live almost a normal life. Particularly for foreigners, it is difficult for them to find the security because they are probably poor, not earning enough, maybe not even in a job. So their difficulty is getting the security, getting the bail conditions, etc. So I think at the end of the day, I would suggest that the best policy is to allow them to go out with electronic monitoring. Of course, that also costs money, because to monitor somebody's movement all the time, because he's wearing an electronic bracelet, is also employing somebody in some police station or somewhere, looking at him continuously to see that he's not breaching his conditions. But bottom line is, what is the better of the evils? I say, give him the freedom. He has to accept that his freedom is at the cost of lack of freedom to move automatically everywhere. But at least he will have the freedom to, particularly to work. I hope I've made my points clear.
Thank you, thank you. Alexia, Erik?
Yeah, we totally agree with what Mr. Mohammed said, but yeah, that's the best of two evils, and but there's also our opinion was where we want also yeah, our point, the point that we want to make is that it's not because alternatives are less intrusive than pre-trial detention, for example, that we cannot ignore there's also a violation of the presumption of innocence, and so that both have to be used as an ultimum remedium. Pre-trial detention, but also the alternatives to pre-trial detention. There are also the same criteria, according to Belgium now at least, there are also the same criteria that apply for both pre-trial detention and for alternatives.
Yeah. On the other hand, I fully understand the dilemmas, Alexia, you presented. For instance, when you talk about drug addicts or people with mental health issues, and there is no treatment available outside, or the homeless people. What should a judge do? It's, as Mohammed said, to choose about the evils. Yeah, then where's the balance? I think that is difficult. And of course, of many foreign nationals you mentioned, which is, I think, in every jurisdiction in Europe a problem. Yeah.
If I may have one question to the mental health, I'm just curious. You mentioned that there is lack of adequate treatment for mental health and drug offenders, drug addicted offenders, etc. I assume that the situation is same for people who are under probation from the very first moment. I mean, who are directly sentenced to alternatives.
The problem it's more for people who are in detention and they have no residence and adapted residence. If they are on probation, it's no problem because they have a residence, a family, and so on. But the problem is they are in prison, and it's difficult to have intake interviews with the people in prison. So the institution not have the possibility to go in prison to do the interviews, and then there is a lack of place. So, but it's residential institution. We have a lack of residential institution. It's more that the problem.
Yeah, often long waiting list also. So long waiting list, yeah, difficulties to organize intake interviews inside prison, and also there's also sometimes there's also refusal of some prisoners with some specific profiles. For example, sex offenders who also committed other violent offenders, or people who are convicted for arson. They are very difficult to place, and sometimes institutions also refuse to take these people inside the institution.
In the French part of Belgium, we have only one institution who accepts people for drugs users. Only one institution, so it's possible to. And the problem, it's not we are a federal country, and it's not the responsibility of the federal, it's the responsibility of the region and the community.
Yeah. Okay, I think we have to come to an end of this presentation. Thank you very much. I'd like to mention one more thing because Alexia, you mentioned the impact electronic monitoring can have, and Eric mentioned it too, on the family. And in that sense, I like to mention a dear colleague of us from Belgium, Delphine Verhalemees, I must say. She wrote an article, I think it was called the Pains and Gains of Electronic Monitoring. She did research on that specific topic. And I think it's still available on the CP website. So it was very interesting, her findings, that it has more impact than we thought initially. So thank you very much. And if there are no further questions, I'm looking to Mirka.
No.
I think now it's time to move on to our next speaker. I already see him, Kresimir Kamber.
Okay. Is the presentation
It's working. Yeah, thank you.
Okay, excellent. So thank you very much for the invitation to this webinar, which is, as always, interesting and fascinating to talk about these issues and really to hear the different perspectives on the matter. My talk today will be on the alternatives to pretrial detention in the European Court of Human Rights case law, and we will see that they are something which is somehow already, I would say, present in different domestic legal orders, and we will see that at least on the paper, domestic legal orders are really trying to follow these relevant principles. Whether they are succeeding in practice, that is another question, and this is why I guess we are having today's discussion. So first of all, I would like to say a couple of introductory remarks on the overuse of pretrial detention, which in a paper that is available on CIP's website that I consider to be a public policy and a human rights issue. So it's not only one or the other, but rather both public policy and human rights issue. And I'll explain a little bit later what I mean by this. Then I want to go through some general concepts of the ECHR case law, and then going more directly to the issues of pretrial detention in the court's case law. There is something which I think one of the previous interveners said, there is something little bit of counterintuitive in the pretrial detention. On the one hand, we have a person who is presumed to be innocent, that we as a society, and this presumption of innocence leads to something which is in theory often called as a civic trust, that we have to trust each other, that we are not guilty of crime before proven otherwise. This is critical because our society would be a society of a complete chaos if we would be starting to challenge each other's presumption of innocence. So we do have this presumption of innocence, which is not purely a theoretical matter, but something I think very critical, important for the proper functioning of the society. So we have this individual who is presumed innocent, but he's then or she placed in pretrial detention with risking the possible outcome, which would be incompatible with the fact that the initial deprivation of liberty was ordered. So finally, you may have acquittal or discontinuation of the proceedings, and then a certain disbalance again created between what happened in reality and the responsibility for the criminal offense. My question here is whether the various alternative measures to pretrial detention is a compromise. Can they be seen as a compromise in this, what I call counterintuitive situation? So we don't put somebody in pretrial detention, but we do acknowledge, and that person is presumed to be innocent, but we do acknowledge that some sort of measures of restraint with respect to that person are needed, and then they are maybe in the alternative measures to pretrial detention. This is more of a question than a constatation. Then I would like to point to some of the issues that are mostly related to public policy of penal system of a country that arise with respect to overuse of pretrial detention. And this is first of all the issue of prison overcrowding. Although interestingly, at least to my knowledge, it has not still been in literature, at least shown that there is a clear causal link between the overuse of pretrial detention and prison overcrowding, but we can surely say that pretrial detention significantly contributes to prison overcrowding. At the Council of Europe level, I think we historically have a quarter of detainees that are in pretrial detention. And if you go through various space reports, you will see that it's always about a quarter of detainees that are in pretrial detention. Globally, according to the most recent report on global trends on imprisonment, it would appear that at the Council of Europe level, you had some 30% fall in the use of pretrial detention since 2000. But then when you go a little bit more deeper into details of pretrial detention, like Fair Trials International did in this report of 2021, you see that the picture is a little bit more dramatic than it would appear from this global report. So this Fair Trials International report has gone into some very recent trends from the past year, in particular in relation to COVID situation. Then it looked into particular countries, and then we see that in fact pretrial detention is always a little bit on the rise. So it's still there. Detaining somebody in prison is extremely expensive. We have seen what the amounts of money that are spent, which are regularly reported in space reports. I think it goes approximately to 70 to 80 euros per day per prisoner who is kept in detention, which then finally amounts to extreme amounts of money. And somebody who would do the pure economic assessment would maybe also compare the alternatives to pretrial detention from this perspective as well. Then, of course, from the recent case law of the Court of Justice of the European Union, we have seen that the overuse of pretrial detention and then the problem of prison overcrowding is a problem also of mutual legal recognition in the context of EU and in particular in the context of the European arrest warrant. There are also various individual effects, human rights effects that affect people in pretrial detention. So we have in cases irreversible impacts on livelihood, on family relations, on health of the person concerned. Reports of a risk of suicide are much more present when it comes to, the risk of suicide is much more present when it comes to pretrial detention and short-term deprivations of liberty, so the initial shock on the individual. Then the logic of schools of crime, somebody who enters pretrial detention and then starts with serious criminal career, which he or she didn't have before. And then pretrial detention is, according to many reports, very often linked to discrimination, to prejudice against those who are in fact most vulnerable in a society. The court has, when I say the court, I'm referring to the ECHR, has adopted many pilot and leading judgments. Leading judgments are those which are sometimes called quasi-pilot judgments, so those where the court is providing different indications to member states on the measures that need to be taken to effect, to address the particular systemic problem in the country. They are mostly related to issues of prison overcrowding and other inadequate conditions of detention, and very often they are also linked to the problems of pretrial detention. Article 5, which of the European Convention on Human Rights, which guarantees the right to liberty, is statistically the second most often breached provision of the conventions is the existence of the court to the currently available statistics to 2021. This should be, however, taken with caution because, as you know, Article 5 is a very broad provision which covers not only pretrial detention but all sorts of various issues relating to deprivation of liberty, such as immigration detention and so on. But still, it's an indicative information to bear in mind that Article 5 would be the second most often breached provision of the Convention. When it comes to the general concepts of the court's case relating to imprisonment, I think the first one is the one which is most critical. And this is something that I often use when I have meetings or discussions with domestic judges. So the general rule is that everyone has the right to liberty. So what I often say to judges at the domestic level, when an individual is there in front of you, irrespective of the kind of charges he or she faces, your first instinct towards that individual, your first information that you have in your mind should be, okay, this individual now has to be released. He or she has to be at liberty. And now let's see whether somebody has made a proper case to keep him in pretrial detention. So I think that this principle, that this general rule that everyone has the right to liberty is the critical principle for any further discussion about these things. Then there is something which is often confused when it comes to the issues of personal liberty, and this relates to the fact that the case law relating to individuals with mental disorders was then, I would say, in a non-critical way, translated also to pretrial detention. So you would sometimes have discussions that somebody may have agreed to deprivation of liberty. In other words, did not contest at the relevant moment or did not raise some particular objections to the first deprivation of liberty and so on. But that doesn't mean that the deprivation of liberty is lawful if somebody did not contest one or another decision in pretrial detention. And that's something important to be borne in mind. Article 5, when it comes to pretrial detention, puts 3 critical requirements. First is that there is exhaustive nature of exceptions under the right to liberty, the first principle that I mentioned before, and these exceptions have to be interpreted strictly, and they are not subject to some sort of balancing proportionality assessment like we would have under Articles 8 to 11 of the European Convention. Then there is a critical emphasis on the lawfulness of detention, lawfulness both in procedural and substantive sense. And of course, it is important that there is a prompt, speed, and effective judicial control of any deprivation of liberty. When it comes to lawfulness, what is important to stress here is that lawfulness implies strict compliance with the domestic law. And the domestic law here is not only a national law, but it's also international and EU law, which is applicable in a particular state. Lawfulness requires not only that there is a legal basis, but that legal basis has to be of certain quality. So it has to be accessible, it has to be foreseeable for the person concerned, and there has to be certainty in its application. And then the relevant law must also be in compliance with the relevant convention standards on general standards on human rights. Protection from arbitrariness is a little bit tricky topic because arbitrariness is not as such defined in the court's case law, and we can have different views on what's arbitrary and what's not. But in general, the test would be that there is an element of bad faith or deception on the part of the authorities, or where the authorities apply the relevant, there is an attempt to apply the relevant legislation incorrectly. So there is some sort of I would say, a hidden purpose of the authorities when deciding on pretrial detention. That would be an element of arbitrariness. And then necessity, the deprivation of liberty must be necessary in the circumstances. And you see, this is the next principle is very important for our discussion today, which says that detention is justified only as a measure of last resort, which means that less severe measures have to be first considered. They have to be, in the particular case, found to be insufficient to safeguard individual or public interest, and then only detention may be ordered. So that's the principle of necessity, which is applicable across Article 5, so to any deprivation of liberty under Article 5. The principle on pretrial detention, which links to the principle of personal liberty that I mentioned previously, is that there is a presumption in favor of release. This means that it's the responsibility of the national judicial authorities to show in every single case that the pretrial detention, first of all, has to be ordered, and secondly, that it does not exceed a reasonable time. Domestic authorities would also need to show that there has to be, and they need to demonstrate the existence of facts which are in favor of deciding on the deprivation of liberty, which means that their decisions must weigh the relevant facts and relevant arguments in favor or against the release. There are three specific grounds for the continued deprivation of liberty. When I say continued, this is the one that goes beyond the initial deprivation of liberty, which basically happens already in the measures of, in the question of hours. And this is that there has to be a reasonable suspicion that an individual has committed an offense. The requirement of reasonable suspicion, I guess, would exist in many domestic orders, and it relates to the existence of certain objective information and facts which should convince an objective observer that an offense has been committed. Then there has to be relevant and sufficient reasons justifying the detention, and these relevant and sufficient reasons are those which even our colleagues for Belgium mentioned, and this is the risk of flight, the risk of collusion, the risk of reoffending, and in some exceptional situations, the risk of the general risk to public order. And then, in addition, as the third requirement, there has to be special diligence in the conduct of the proceedings. And all these three requirements must be cumulatively met in order for a detention to be justified. It is not on the individual to show that he or she should be released, but it's on the authorities to show that he or she should be detained. This again links to the principle of individual liberty. All the measures which would work in an automatic or quasi-automatic sense, in the sense of ordering or prolongation of liberty, such as measures of, for example, mandatory deprivation of liberty or mandatory refusal of alternatives to pretrial detention, would be per se incompatible with Article 5. Similarly, using stereotype formulae which are simply reciting the domestic law without making reference to specific facts of a case would fall under the same category of unacceptable deprivations of liberty. Whenever faced with the necessity to order pretrial detention or to extend pretrial detention, the domestic authorities have the obligation to examine the possibility of ordering alternatives to pretrial detention. They must examine whether there is a possibility to release individual under what the court in general calls, and you have to be aware that the court is dealing with 46 different national legal orders, but the court calls less severe preventive measures if the detention of a person is no longer reasonably required under Article 5.3. The court has, however, in some instances accepted that the domestic authorities have managed to demonstrate that the alternative measures in a particular case would not be effective and have provided for that relevant and sufficient reasons, and has therefore accepted that the pretrial detention was justified without ordering ordering alternative measures. But here, it's critical that the domestic authorities have engaged with this and provided relevant and sufficient reasons. Rather complex requirements exist with respect to bail. When I use the word bail here, I'm primarily referring to financial bail. So the principles would be that an automatic refusal of bail would be per se incompatible with Article 5. Again, similar like to other alternative measures. Then, however, bail can be ordered only as long as the grounds for pretrial detention prevail. If there are no grounds for pretrial detention, bail cannot be applied on itself as a self-standing measure. Then you see this is where the complication arises, and this is the manner in which bail should be set in order not to run counter to Article 5. So it has to be set with regard to the person concerned, his assets, relationship with the person who is providing the security, to the degree of confidence that it is possible that the prospect of loss of security of the guarantor would ensure that there would be appearance at the trial. And at the same time, it can be also, what can also be taken into account is that the amount of money should be a sufficiently deterrent measure to dispel any idea of absconding. In some instances, the amount of the loss which is impugned to the accused can be taken into account, but this should not be used as a rule, given the presumption of innocence, of course, but rather the previous criteria that I mentioned should be the one guiding the setting of a bail. And then finally, the problems which you would mostly find in the case law of the court is that you would have cases where the domestic authorities did not set out the correct amount of bail, or where they set simply an excessive amount of bail and thus de facto preventing an individual to be released from detention on bail. So these principles, which are, I would say, very much intuitive and which are integrated already in a good number of domestic systems, are those that would flow from the court's case law. So I thank you very much now for this, and I'm, of course, happy to answer any question that you may have.
Well, thank you, Kresimir, for this, I think, very interesting presentation. I think from the point of view of the law. Of course, I have some questions, but I'm looking to Mirka. You seen questions coming in?
No, not yet.
Okay. For me, Kresimir, a question is, are there differences between interpretation and between the various jurisdictions? Because, yeah, in some jurisdictions, pre-trial detention is a big issue, and prison overcrowding. For instance, in the Netherlands, we have no prison overcrowding. And I think in the Netherlands, we don't pay that much attention to pre-trial detention because we have empty cells. That is a luxury, of course, but are there differences? Can you elaborate a bit on that?
I'm not particularly fan of drawing differences in Europe between different countries, because drawing differences is always critical. That a country may say, with us there is no problem, and then we can more or less forget about all this. There is no country when there is no problem, I think, with issues of human rights and detention. But if you now ask me to draw some differences, I would say that as more east you go, you would have countries more inclined to order pretrial detention than alternative measures to deprivation of liberty. The more west you move and more north with respect to Nordic countries and so on, you will have I think the application of alternative measures to pretrial detention and so on, which of course doesn't change the fact that you had a systemic problem in French prisons with overcrowding. It doesn't affect the fact that you had systemic problems in Belgium and so on and so forth, which again comes back to my previous disclaimer that I said that it's difficult to say that there is no country which is without sin in this sense. But some sort of regularity would be, I think that more you move east, countries would be more having these problems of being more inclined to order pretrial detention than often.
Yeah. Perhaps it's also to do in some jurisdiction, let's say the former Eastern European countries, probation is not yet that well developed. Sometimes we talk about a very small organization. So we've seen that in the former presentation, they are not involved in any way of pretrial detention. That can be an issue too. Yeah. Yeah. I have another question. I think it's a very important principle, the principle of necessity. Yeah, that prison is the last resort. Detention is the last resort. Is that accepted everywhere in Europe? As perhaps more or less the same question as the former question, but could you elaborate a bit on that?
I think I think on the paper, probably many legislations you would find that the prison should be used as a measure of last resort, particularly pre-trial detention. But then in practice, I'm not sure that this is still the case. And I have a feeling, I think it was mentioned in the previous presentation as well, I have a feeling that very often judges who are deciding on individual liberties are very much under the impression of the severity of the crime, maybe even on media pressure created at the moment, and so on. And that's why I said that when I speak to domestic judges, I always say that the principle which is in your domestic laws and which follows from the case law of the court is the principle that the deprivation of liberty should be a measure of last resort, has to translate in practice for you to say that irrespective of the gravity of the charges, irrespective of the public fuss created, when you sit facing the individual with respect to whom you're deciding on pretrial detention, your first thought should be this individual now, when we finish this discussion, he goes home. And then I have to really, the prosecution really has to convince me that this should be otherwise. That this individual doesn't go home after our discussion, but that he goes to pretrial detention. And I think it's easy to say this in theory, and of course, but I think it's important that at the domestic level, judges start thinking in this way when approaching pretrial detention.
Okay. Mirka, are questions coming in?
Yeah, actually, we have one question again from Mr. Muhammad Iman Ali, and then we have one Q&A. If you agree on it, that I would start with this Q&A. The question is whether the bail recommendation from the European Court of Human Rights, if there are any kind of similarities with implementation of fine as a sentence.
Similarity with implementation of fine as a sentence. In what sense? Do they have to correspond to the amount of fine? Is that the question?
No, the only like more close explanation is as a usual function of probation services that just came in addition to this question.
As I understand the sentence, the question, and maybe I misunderstood it, is that the question is, should the bail correspond to the amount which is impugned to have been obtained by crime? Is that the question? If it is, then that's a tricky point. Again, because of the presumption of innocence, you are still aiming to discover whether the individual has committed this criminal offense, and he or she may have not obtained that amount of money. It was heavily criticized by the applicants in previous cases that came to the court, that the court was not sufficiently sensitive to this aspect and was allowing different states to apply bail corresponding to the amount which was allegedly obtained as a result of the criminal offense, which shouldn't be so. And therefore, in that Grand Chamber case that is mentioned on the slides, and I believe that these slides would be available to the audience, it was said that this is something that can be borne in mind, but shouldn't be the critical reason for deciding on bail. Bail should rather be decided on the other elements, and this is the actual possibility to provide for the bail. Does it use as a deterrent factor in order to ensure the presence at the trial, and so on and so on. I'm not sure that it answers the question, but there you are.
Thank you. Then we have another question. Yeah, from Mr. Mohammed Iman Ali.
Yes, can you hear me?
Yes.
Yep, we can hear you.
Good. It's interesting that Kresimir should call the institution a school of crime. When I lecture to judges and lawyers, I tell them that it's a free university for criminals. Because what happens is that the people who are particularly in pre-trial detention, they're only there for a short while, and they meet up with the long-term prisoners who are staying in there, and who then give instruction to these people who are temporary only. Look, you're going out next week. When you go out, you'll probably not have a job, no income. Go and meet my friend so-and-so, and he'll give you something to do and give you some money too. So we are building a criminal society by doing this, by sending people to prison on a short term particularly. One other thing that I would like to just ask again is that Kresimir mentioned 70 to 80 euros per day to keep someone in detention. I don't think we've come across any measurement of how much it would cost to keep someone outside on liberty by way of electronic monitoring. Again, I say, go back to what I said earlier, you balance. If electronic monitoring costs less, then use that. The other thing is that electronic monitoring would only be necessary or would only come into an expensive way of monitoring if and when the person breaches the conditions. In other words, moves out of the reach of the electronic monitoring. An alarm goes and he then has to be chased by police. Otherwise, if he's within his conditions, then nothing happens, no costs involved. The other thing that I would suggest is, again, depending on the cost effectiveness, is supervised release. In other words, you can have released someone who will then report. Let's say if he's seen to be such a bad criminal or bad person or bad risk, then report every day to the police station so that we can keep tag on his movements. This, again, little bit of cost involved, but the balance is, where is more cost? Where is more liberty? You're at a certain cost, you're giving him more liberty. If you take somebody in general public who is about to be detained, his income drops completely. If you release him on bail or release him on condition of free movement, etc., then you're allowing him to make a living. His family is not thrown on the streets. His children do not become beggars because they don't have any income in the family. So again, we go back to you balance the costs. The other thing is, of course, serious criminals, drug dealers, for example. You put a security on their release. What's money? In a drug dealing situation, you give the security, you make the money by selling more drugs. What are you doing? You're making him a better criminal. Now, the other interesting thing I heard is that Netherlands doesn't have overpopulation in the prisons. Yes, I understand it. Netherlands rents out prisons to the British because the British can't cope with their prisoners inside their prisons. But the idea is not about overcrowding solely, but about liberty.
Yeah.
Allow a man to be out if we can afford to let him out without incurring more crime or incurring more cost to the system. Thank you.
Thank you very much for your remarks. I think they're quite useful. Kresimir, you have the last word.
I fully subscribe what Mohammed said. I think what would be interesting here to see some studies. I mean, when you have the number of 70 to 80 euros, that's your costs of imprisonment, regular costs for food, accommodation, and these kind of things. But what about the other costs that Mohammed just mentioned about effects on the family, on the livelihood of the family, effects on What about the damages that the state finally has to pay for the prisoner because of overcrowding or other problems that is awarded by the courts and so on and so forth. So I'm sure it would be an interesting economic exercise to do to see how much exactly do prisoners cost the state in a country. But otherwise, I fully subscribe to what was said before.
Okay, and Mirka, there are no
Yeah,
more questions?
I can take a look on the watch. We have still one person who has a question. So if you agree on that, I would.
Yeah. Short question, short answer.
Yes. Can you hear us?
I can. Can you hear me?
Yes, we can.
This is Walter Hamschick from Austria. Good day to you. First, a remark on electronic monitoring. I'm not at all opposed to electronic monitoring in case of pretrial detention. I just want to say we always have to be aware of the high risk of a net widening. Like Eric and Alexia described, this is a serious risk connected to electronic monitoring. I would like to point at the high level of discretion judges have in pretrial detention cases. And of course, this is also needed, no doubt about that. But when we come to alternatives, we observe in empirical studies that judges have little trust in the alternatives. On the one side, there's media, the media pressure, etc. And in the end, in most countries, judges get along without really substantiating very much why they don't use the alternatives. And I think this is a problem. And so my question would be to Kresimir, wouldn't you think that there would be that there should be good chances to succeed if cases would be brought forward to the court, saying, well, there's hardly any substantiation why alternatives are not used? Thank you.
That's a very interesting question you raised, and I'll try to give an anecdote here. Very often you will have pretrial detention which is extended every 2 or 3 months, depending on the legal system, but approximately that would be every 2 months. And then when you read one detention order from another, and it's interesting when you are in the highest court, then you sometimes see from day one until the final day of the proceedings. So you see many of these detention orders. And then you compare them, and they are more or less contain exactly the same wording. It's simply copy paste that somebody changed the date in the heading. And then I remember some of my discussing with some of the colleagues here who would say, but what could the judge say after 2 months? If nothing changed, what's there to say anymore? Is there something new to say to what was not said 2 months ago, if the circumstances are the same? But here we come to what Mohammed also mentioned previously. It's the question of individual liberty. It's the question of the basic respect towards that individual who is in pretrial detention, that the judge needs to sit seriously over his case, and even after these 2 months to assess whether now this person should be released on alternative measures, and to provide some reasoning why not. We cannot have the society which is functioning so that the judges change the date on the detention order and keep the reasoning the same. But therefore, you will see that in the court's case, that you do have this principle that reasoning should not be stereotyped, that should not be constantly identical and repetitive, and so on. So the court's case law does require that the judges engage with the case every time they are extending detention orders, and every time they have to explain why alternative measures will not be adequate in an individual case. But unfortunately, that's still not happening at the domestic level, and therefore I think it's also important that the lawyers raise these issues and that this is brought to judges' attention, that they're simply forced to decide upon these things.
Okay, thank you, Kresimir. I'm looking to Mirka. I think no more questions.
No questions.
Okay, then thank you very much, Kresimir, for your presentation. what is good to know, it's time for a coffee break. Well, we're doing quite well, I think, but we take something like 10 minutes. Is that okay for you, Adriano? Yeah? So let's say 3-4 minutes to 12, we continue? Okay, good, because I need coffee too. See you in 10 minutes. Thanks. Hello, we're back for the last session of this webinar. I'm pleased to give the floor to Dr. Adriano Martufi. And as I said, it's an intriguing title, Underused, Ineffective or Useless, a normative appraisal of non-custodial alternatives to pretrial detention under European law. Adriano, the floor is yours.
Thank you, Willem. Thank you very much for your kind invitation. I have to apologize, first of all, because I'm not going to use a PowerPoint presentation, in that I thought of this occasion more of a conversation with you, especially because mine is the last presentation of today. And I would mostly try to raise some questions, hopefully, to be able to address them with you during the discussion later. So my presentation really presents a normative appraisals of alternatives to detention in Europe. And to carry out this appraisal, this evaluation, I'm going to look at the alternatives to pretrial detention from a human rights perspective. So from a normative perspective that builds on human rights and the human rights framework that exists in Europe. And so human rights are, of course, a common language that transcends national differences, legal diversity, and the different labels that we can use under national legislation to refer and to talk about alternatives to pretrial detention. So that's why it's so important to use this common grammar, so to speak. If you want to kind of reconstruct the European standards that can apply to pretrial detention and its alternatives with the view to reduce prison population and the share of prisoners on remand. And of course, the backbone of such standards in Europe is provided by the case law of the European Court of Human Rights, as we heard in the previous presentation. The importance of discussing the normative framework for the alternatives to pretrial detention is very much related to some empirical evidence that we have about decision-making when it comes to applying pretrial measures that do not involve deprivation of liberty. As we heard from one of the previous participants in the Q&A session, a great deal of discretion is still in the hands of decision makers, and especially judicial decision makers, when they have to decide between bail and detention. And in a recent special issue that my colleague Cristina Peristeridou and I have edited for the European Journal of Criminal Policy and Research, we collected a number of interesting case studies that delve into the dimension of judicial and in general judicial discretion, but in general decision-making discretion when it comes to this alternative between pretrial alternatives and pretrial detention. And so the question that we want to ask is really in how far the normative dimension, the normative standards, including those based on human rights, can restrict, reduce these judicial or normative discretion. In how far can these normative standards prevent heuristic thinking and stereotypical reasoning that often prevails when it comes to the alternative between bail and detention. And in fact, our conclusion that we presented in a recent publication by drawing on the evidence provided by empirical research is that unfortunately the normative standards, even those based on human rights and the European Convention on Human Rights, have been pretty insufficient to restrict and reduce this judicial discretion. And here I would like to focus in particular on one set of normative standards that we heard in the previous presentation, about in the previous presentations, those that refer to the so-called principle of last resort, of extrema ratio, which prescribes under Article 5 of the Convention that the privation of liberty, especially prior to or pending trial, should only be used as a last resort. And so our conclusion is that these standards and the standards related to the principle of extrema ratio do not provide an effective constraint on the use of alternatives. They cannot present a binding enough obligation or normative standard to reduce the use of pretrial detention and increase the use of alternatives. So just a short digression to repeat what has been said in the previous presentation. So the legitimate grounds to use pretrial detention under the European Convention are essentially 5, and they relate to some risks that are posed by the suspect or by the defendant. So pretrial detention is, in essence, a risk predicting exercise that is carried out by the decision makers. These risks are the risk of absconding, the risk of tampering with evidence, the risk of reoffending, and the risk of disturbing the public order. All of these risks essentially draw on similar grounds that legitimize the use of pretrial detention under national law. So if these are the risks that justify when pretrial detention is legitimate and not only lawful, but also necessary, we also have to reflect on which grounds allow national authorities to opt for non-custodial alternatives. So in fact, under the case law of the European Court of Human Rights, which is very much referred to also by the case law of the European Court of Justice, the obligation to provide a non-stereotypical reasoning when a court decides on the alternative between detention and bail is very much connected to a duty to consider alternatives to pretrial detention. And this duty is fulfilled only when the court, the European Court, is satisfied the national authorities have in fact carried out a thoughtful and thorough examination of the facts of the case and evaluated whether pretrial detention is justified in relation to the risks posed by the suspect. And the court has also gone too far and more far than this, and said that when a national system is designed in a way to impose a judge or a court to automatically refuse bail without a case-by-case assessment of the facts of the case, that would be incompatible with the convention. The court has said that in the case of Caballero against the United Kingdom, for instance. And despite that, in fact, many provisions exist under national law in several member states of the Council of Europe that in fact oblige essentially judicial decision makers to opt for pretrial detention instead of bail. And so if we look at the ECHR standards, what we see is that on the one hand, we have an obligation to seek for the use of alternative measures and at least to consider them as a possibility based on the facts of the case. And on the other side, we see an interpretation of the human rights standards that presupposes that pretrial detention and its alternatives fulfill the same function, so that there is a functional equivalence and only a difference in the degree of risks posed by the suspect. So we have to bear in mind this functional equivalence. But first, I would like to reflect on the duty to consider alternatives and why is this duty not enough to prevent stereotypical reasoning, heuristic thinking, and judicial discretion that would make it more and more frequent for as we saw, for instance, in the case of Belgium, for judicial decision makers to use detention instead of bail. So the problem with this duty to consider alternatives is that the concept of alternatives, even the concept of less restrictive or non-custodial alternatives, which are two synonyms that the court often uses, are not very much specified. They're not interpreted in a clear way. And that's a problem because there's no European consensus about what alternatives to pretrial detention mean. Even the concept of bail is used in very different ways across the legal spectrum in different member states and in different contexts. So, for instance, in some comparative studies that have been funded by the European Union in the last few years, the concept of bail is only used to refer to financial guarantees or financial securities that will make sure that the suspect will then show up at trial. By contrast, in the English-speaking countries, especially, and in the English-speaking literature and the English native speakers that are here today can confirm or deny this claim. It's a concept, the concept of bail, that is more commonly understood in a broader sense as a synonym of a status rather than a single measure. And the status is the one of a suspect that is obliged to show up before the court or before the police. And some conditions, including the supervision by a probation service, may be attached to this status. So this is a problem already by, in terms of definition of what we mean by alternatives. And second of all, the way in which alternatives are used across the member states of the European Union and the Council of Europe tend to vary quite significantly. There are at least two models that we can think of in which these alternatives are used. And one is the so-called bail model. I guess that was something that was also referred in the first presentation by Alexia and Eric. And it is a model that allows, for instance, in England and Wales, the judicial authority or the competent authority, it may also be the police in some cases, to choose from the very first moment between unrestricted liberty as sort of financial guarantees or the possibility of supervision under some condition. So that is also referred to as conditional bail. And only at the furthest side of the spectrum, there is the possibility of the remand in custody. So you have like this continuum of different measures that can be taken between unrestricted liberty up until remand in custody with a different level of intensity. And then there is a different model, and the suspension model, in which that is prevalent in continental Europe, and countries such as Belgium and the Netherlands, for instance, that requires that the judicial authorities is satisfied that the grounds for pretrial detention are fulfilled. So, for instance, the risk of absconding is present, and only on this basis can then decide whether or not a less restrictive measure, like, for instance, house arrest, electronic monitoring, or even a financial security can be applied. So these two models are completely different, and therefore the lack of a unified definition of what we mean by alternative in Europe, and even within the case law of the European Court of Human Rights, makes the obligation to consider the alternatives very much less effective. So that's a first explanation. And then there's a second possibility to approach the subject matter, and I'm quickly going to my conclusion. And if we look at the Article 5 of the European Convention of Human Rights, we see that, in fact, Paragraph 3 refers very much explicitly to the possibility of releasing a suspect by applying some guarantees that he or she will appear for trial. So a first interpretation of this very, very schematic provision will suggest that the only concept of alternative that exists under the convention is one that is referred to as financial bail. And in fact, a certain number of cases seem to refer only to bail as the alternative to pretrial detention, the only alternative to pretrial detention for which a duty, a legal duty exists. There are other cases that take a different interpretation, a broader interpretation, and that interpretation would suggest that we can also refer to other sorts of measures as alternatives to pretrial detention. But then the question arises, and that takes me back to my second point earlier, so the functional equivalence between pretrial detention and its alternatives. Are alternatives to pretrial detention always adequate to fulfill the prevention of risks that justify the use of pretrial detention? Because if we assume that alternatives are to perform the same functions of pretrial detention, and that's the reason why we can opt for them, we have to seriously wonder and ask whether those purposes can be fulfilled. So for instance, bail, financial security, is often a very effective way to prevent the risk of absconding. But is it an adequate enough guarantee to prevent other risks that pretrial detention commonly tries to address? For instance, the risk of reoffending, or the risk of disturbing the public order that in some jurisdictions, such as the Netherlands, is one of the most recurring grounds to apply for pretrial detention. Unfortunately, the conclusion is that especially financial bail and other less restrictive measures are not always adequate to replace pretrial detention in the groups of cases that I just mentioned, just for instance, preventing reoffending, for very practical reasons somehow. And so the question is what the Court of Strasbourg says in that respect. Unfortunately, if we look at the court's case law very carefully, we realize that especially when dealing with grounds for pretrial detention, such as the risk of reoffending, which represents one of the most commonly used grounds for pretrial detention in the empirical analysis, and at least what we see from the empirical evidence in many countries, the court accepts that alternatives may not be a sufficient measure, irrespective of the risk, of the level of dangerousness and risk posed by the suspect. In other words, alternatives are simply not adequate to deal with some kind of risks. Therefore, this denies the very assumption on which the whole human rights standards of the European Court of Human Rights are based, namely the functional equivalence between pretrial detention and alternatives. And the final problem that I would like to sort of raise here as a question for the discussion, really, and I'm pretty sorry that the previous speaker had to leave, because that's a question I would like to raise also to someone working within the Council of Europe and within the court especially, is whether some alternatives to pretrial detention, if we can call them this way, including the electronic monitoring, when they imply a very intense restriction of the freedom of movement, would fall under Article 5 of the Convention, and they will then be tantamount to a deprivation of liberty, or under Article 2 of the Protocol number 4 attached to the Convention, which protects the right to the freedom of movement. And in many cases, the court has, for instance, said that night curfews with some obligations, including reporting to the police, to the probation service, are in fact only minor restrictions of the freedom of movement, that they do not qualify as a deprivation of liberty. Therefore, they can be regarded as alternatives to pretrial detention. But when electronic monitoring is so intense and so pervasive, is that a form of restriction of freedom of movement, or is it a fully fledged deprivation of liberty? And if so, will that qualify as an alternative to pretrial detention, thereby meeting the standards of Article 5 and the principle of necessity and the principle of extrema ratio. So these are all questions that I would like to leave to the further discussion. And I will leave it there for now. Well, thank you very much for your attention, and I'm very much looking forward to the discussion. Thank you all, and thanks again for the invitation.
Well, thank you, Adriano. Indeed, it was an intriguing subject and an inspiring presentation. Thank you for that. Mirka, are there already questions?
Not yet, not yet.
Okay. As you know, I always have a question.
I know.
Adriano, you said there is, can you please elaborate on that? There's no European consensus on the definition of pretrial detention and the bail model. Is that necessary? Is that essential? Do you?
So I don't think we need to agree necessarily. As an academic, I'm not prescribing any specific policy recipe that will be more advisable than others. So I don't think we necessarily have to agree on a certain model. So on the bail model, as opposed to the suspension model. What I'm pointing out is that the obligation to consider alternatives to pretrial detention that is based on the human rights framework would completely lose bite. And in fact, our assumption is that it has no bite whatsoever if we don't agree on what the content of such duty or obligation would be. And to clarify the content of this duty, we need at least to have some clarity at the European level on what kind of model we have to have in place to apply and consider alternatives. In fact, in some case law, in some pieces of case law of the European Court of Human Rights, there seems to be a slight preference for a bail model. And in some comments on the case law, it's often referred to as a presumption of bail, which would seemingly refer to the bail model. But of course, the legal diversity and the significant deference that the court has towards national discretion, the margin of appreciation, the legal traditions of each jurisdictions, including especially continental jurisdictions that are very much inspired by an inquisitorial model of criminal procedure, including Belgium and the Netherlands, to mention only a few, makes it very difficult to put forward a single model of bail and alternatives to pretrial detention. And that is understandable, of course, but that makes it very much less enforceable for the courts to refer to this duty in a way that is consistent and effective to reduce the use of pretrial detention. So that's our finding, at least.
Okay. Mirka, some questions coming in?
Yeah, we actually have a few discussions. So I will start from the very first participants from Austria who raised his hand.
Hello, Adriano. This is Walter from Vienna. Good to see you again. I fully agree with you that one problem we definitely have with the alternatives, we simply cannot say alternatives are the size which fits all. Indeed, definitely, there are always cases for which we wouldn't have the right alternatives. The problem we do have, I think, in this respect, is that we have very little knowledge, very little evidence on what works where. And the dynamic is of such that the judges and the prosecutors tends to kind of react in the negative way, simply not considering alternatives. For instance, a very well-known example is we have very little evidence on how alternatives work in the cases of risk of escape, flight. And still, if you ask or talk to judges, they would tell you, well, there is a risk. And if you ask them, how often did you face this risk? Well, not often, but I have seen it and we've heard about it. So if we have no evidence, if we have no empirical data, that the dynamic is of such that it's assumed that it is there. And of course, it is there. What remains is the problem that in most countries, in most cases, we don't have a sufficient risk assessment. And I think this is something which should be required much more obligatory, also by the courts. If we collect more evidence, this would also be a basis for the courts to react on.
Yeah, absolutely. And I completely agree that we don't have enough evidence on risk assessment. So the only evidence we have, which is of course developing the last few years, has to do with risk prediction tools, which are of course an important instrument, or might be an important instrument in the hands of decision makers, and which can also rely on, and I'm glad to talk about this in this context, on a very fruitful cooperation between judges, courts, and probation services. So the information collected by the probation services and their analysis and their insights can actually contribute to developing these prediction tools that then can be used by judicial decision makers. But the point is that I think most of the studies we have on risk prediction tools seem to assume just black and white alternatives between the right to liberty, and so the complete freedom of the suspect, and detention. What we should need is probably a number of studies that will investigate a more comprehensive and complex set of alternatives, which span from complete liberty, detention and deprivation of liberties, and several forms of restriction in the rights and freedoms of the suspect, which have to be proportionate. So if on the one hand, we need I think a clearer focus on proportionality, which is lacking at present in the human rights framework. What we also need, I think, is a more thoughtful analysis of the complexity of judicial decision-making and risk prediction, which is not just black and white, as some studies on risk prediction tools seem to suggest, but it's in fact, or should be, and that's where I think empirical evidence can sort of be fruitfully used to develop human rights standards, but should be in fact a more complex set of variables, which include different forms of restrictions based on the different level of intensity of risks and dangerousness posed by the persons involved. So I would suggest that we kind of try to develop research in that direction.
Okay, thank you, Adriano. Thank you.
If I may react, or just minor reaction, I fully agree with Adriano. Yes, that's it. I may actually just kind of highlight the point which is closely connected to it, is the need for information. The judges actually should be able to build their decisions on, and I may refer to the Dutch example. In as far as I know, in the Netherlands, prosecutors and judges can rely on support and assistance by the probation services to prepare the decisions, and this is something I also highlight now in our pre-triad project, which is very, very important, because most judges and prosecutors agree that they base their decisions on little evidence, on little information, and still they're quite reluctant to kind of formulate a demand in this respect. Because why? Their problem is they're always under time pressure. But even if there's a time pressure, and that's true, even if they get this information late, let's say only for the second hearing, then it's still a good information, which might be very valuable for the decisions.
Yeah.
Thank you. Now I'm quiet.
Yeah, no, of course, I agree on that, Walter. So thank you very much. I think, Mirka, we have a few more questions to go.
Yeah. We actually have a question and comment from Mr. Paul Dorant in Q&A. He first thanks you for your presentation, and he's mentioning that he was interested in your point that reporting to police and probation are minor deprivations of liberty. And his question is whether you are aware of any research as to what is the most effective condition of bail, finance reporting or electronic monitoring?
Yeah, I thank you very much. Okay, so I think these are two questions, one in a sense. So the first question is about, and I had to go very quickly on that point. I'm aware of that. I mean, with the different legal basis to apply fundamental rights standards, depending on the intensity of the restrictions and the conditions imposed on a suspect. And if they are so intense to qualify, like for instance, a complete house arrest without the possibility of spending any time out of the place of residence, not even to do to perform any kind of work activity, that is definitely equivalent or tantamount to a deprivation of liberty in prison. There's no doubt about that. The court has said that very clearly in the case of Budzagi against Moldova. Then, besides this very, I would say, exceptional cases, you have a very huge spectrum or a huge gray area of restrictions, which are impossible to, I would say, predetermine in the law, also because of the discretion that is left to the decision makers to adapt the contents of alternatives to pretrial detention in the individual case, which may impact on the freedom of movement and on other rights of the person subject to an investigation in very different ways. And so these are minor deprivation of liberties in the sense that they only restrict the freedom of movement. They can be regarded to restrict the freedom of movement if a person, for instance, has to report to the police or cannot leave the certain area, a district or the city, and has to report to the police to make sure that these prescriptions are fulfilled. And these kind of alternatives do not qualify as deprivation of liberty, but only as a restriction to the freedom of movement, or in the case of the electronic monitoring, as was said several times today, some kind of restrictions may have to do with the right to family life or the right to private life, and therefore can have to be considered carefully from the point of view of human rights, but do not benefit from the same level of safeguards and protection, including the obligation for a judge to order such deprivation that is present, that has to apply when a deprivation of liberty under Article 5 is in order. And then when it comes to the most effective alternatives, I guess it very much depends on how we measure effectiveness, I would say. So then, of course, we for sure knows that pretrial detention increases the likelihood of a suspect to then be subject to incarceration and to custodial sentences at the end of trial. There is consistent empirical evidence in this respect. So if the point is, what is the measurement of effectiveness to avoid any kind of bias from the judicial decision maker, from the sentencing court at the end, I would say any sort of alternative may help to reduce that. Then if the question is more in the long term and oriented towards prevention of reoffending, for instance, then I guess the few evidence that we have from England and Wales and I can provide references to the articles later on, show that electronic monitoring is almost equally as effective, if not more effective, than pretrial detention to prevent reoffending when applied during trial. So, I mean, it really depends what we measure by that. So if the question is how to avoid miscarriages of justice, then the measurement is of one kind. If we try to measure the prevention of reoffending, that's a completely different pair of hands.
Okay, thank you. Mirka, you have one more question, I think.
Yeah, we have a comment or question from Mr. Muhammad Iman Ali. Hello, can you
hear me now?
Yes, we can.
Yeah.
Oh, good. Thank you. Can I just clarify or ask clarification on one issue, and that is that the principle of detention as a last resort not only applies to pre-trial detention, but also to post-trial at the time of conviction.
Yeah.
And really the assessment is the proportionality, as you said, I believe, of the sentence or the punishment with relation to the offense committed. But at the end of the day, we have to keep in mind that the risk assessment is always a subjective thing, because it's depending on the human person or personality of the judge or magistrate involved. If you have 3 judges sitting together deciding on one issue, you'll find that 2 of them agree and 1 of them doesn't agree. And very often you find, I have seen myself, that when 3 magistrates sitting in one bench, the chairman didn't agree with the other 2, and the chairman's version in the end won the day. So risk assessment depends on the person assessing the risk. But at the end of the day, what we have to decide is proportionality, the seriousness, the gravity of the offense that we are dealing with, and the likelihood of the conditions being breached, for example, absconsion, interference with the witnesses or evidence, reoffending, and breach of law and order. We may be wrong. What would be interesting to see is how often on a probation or on a release pretrial detention, how often the conditions are in fact breached. If the result is that it doesn't happen very often, because you remember one thing, when somebody is sent out on condition, he knows that if he breaches that condition, he'll be back in the court, and then he will not be out again. And he will try his level best to keep within the conditions. And particularly, as Adriano said, the conditions of restriction of movement, as opposed to freedom of movement. The restriction of movement is something that if I choose to take it, I will take it, because it is of greater benefit to me to be out at home and with a restriction to report to police every evening than to be behind bars and not see my family and not do my work every day, not earn the living that I could otherwise do. So it is a risk that I take on board because of the situation that I found myself in. I may be innocent for all that it matters. At the end of the day, I may be found not guilty. But the fact remains that somebody somewhere has made an allegation and I am now in the soup for the time being. And the best alternative for me is to go out with some restrictions rather than to stay behind bars totally. So it's all a question of balancing. Which is better? Freedom with some restriction, or no freedom at all?
Okay.
To be with the family, to earn a living, to make ends meet, rather than let the family be deprived of any income.
Okay.
Thank you.
Adriano, a short reaction.
Can you hear me, right?
Yeah.
No, I completely agree. I think that's the reason why part of the scholarship is now so much concerned about trying to develop risk assessment and risk prediction tools to make the variability of sentencing and pretrial decision outcomes less variable and unpredictable, and with the assumption that this kind of tools, if properly based on evidence, will guarantee a higher level of objectivity to and a lesser subjectivity in the decision-making process. So I guess that's the point. But I just wanted to quickly mention a finding from an article we published in the special issue by colleagues Hilde Vermink from Leiden and other two Dutch colleagues that investigate the likelihood of people, of foreigners, of receiving pretrial detention. And foreigners without a home and residence and a home address in the Netherlands are 1.7 or 2 times that more likely to receive, after being arrested, the initial 48 hours of 72 hours of arrest, to be held in pretrial detention than Dutch nationals, and also 50% more likely to receive incarceration as punishment once they have been detained in pretrial detention during trial. So this goes to show, to some extent, that the decision-making is still very much influenced by factors that transcend, to some extent, the real functions of risk prevention of pretrial detention, or that the risks that pretrial detention tries to address are more situational and personological rather than related to the state of the investigations and the protection of the public, as it were. So these are elements that provided by empirical evidence we should definitely carefully reflect about when discussing the level of discretion that decision makers, and in particular judges, tend to have. Also in a comparative perspective, comparing continental Europe, England and Wales, Ireland, which is a very interesting case study in many ways. So that would be only a partial answer to your very, very interesting question.
Thank you, Adriano. We have one more question in the Q&A, which I'd like to address, Mirka, and then a very short answer, because I think people have perhaps other meetings or other obligations, so I'd like to come to an end too. Yeah?
The question sadly is from anonymous attendee, but it's the person asked, which institutions will be more preferable to monitor the alternatives during the pre-trial process?
I think we already agreed on this, all of us, Walter, Willem and myself, that probation services are certainly the better place to monitor and to provide information also on the compliance process to the courts. So I guess that would be the easiest and quickest answer that we can all agree on.
Yeah.
Okay. Then thank you, Adriano.
Thank you
for your presentation. And then, ladies and gentlemen, I think, well, we have come to the end of this webinar, and I'd like to thank Dr. Alexia Jonckheere, Dr. Erik Maes, Dr. Kresimir Kamber, and of course the last speaker, Dr. Adriano Martufi, for their excellent presentations. And I think we can state that their contributions helped us to identify the importance of our work regarding the challenges we face regarding the development monitored pretrial detention. There's still a lot to do. That's what we learned. I mentioned before that the presentations will be available on the CP website at short notice for your reference. And as mentioned, the webinar has been recorded, and most probably we will upload the recordings of the presentations on our YouTube channel as well. So follow CEP on social media to keep track on that. Kresimir Kamber also mentioned an article on pretrial detention of what we published on the CP website. I've checked, and you can still download his article from the CP website, as well as the article I mentioned of Delphine Verhalenmees on the pains and gains of electronic monitoring. And of course, I want to comment and thank all participants for their contributions. You as experts have met at one place and shared related problems and challenges. That was great and rewarding to see. And finally, I'd like to thank my CEP staff members, Ms. Mirjam van der Kooi and Ms. Mirka Jakisova, who worked behind and also on the scene. but always in control and dedicated to make an online event like this to a success. So, ladies and gentlemen, on behalf of the Confederation of European Probation, once again, I thank you for joining the CEP webinar. Have a nice afternoon and stay safe.
Thank you.
Thank you so much.
You're welcome.
Bye.
Bye.